Hi there, Marla Neufeld here. I am a Florida surrogacy and reproductive attorney, and today we're going to talk about known versus anonymous donations, be it sperm, embryo, or egg donations. Now, there's just so many ways you can set up an agreement within the known and anonymous framework that it can make your head spin. In fact, a known agreement can kind of be anonymous. An anonymous agreement can in some ways become known. But I'm going to bring up just a couple ways that people set this up, but it's not exclusive to these methods. These are just some of the common things that I see. So a known agreement can either be between people who just know each other, pretty obvious, right? Another scenario could be that we saw this during both COVID and during the Zika situation, was that clinics required the parties' names to be disclosed with one another in order to allow for full informed consent. So while the names were known, which made it a known donation agreement, a lot of the language in the agreement still kind of kept it pretty confidential, like possibly limiting future contact and not allowing the parties to contact one another without some form of informed consent, which would need to be requested through an intermediary, like the agency or the clinic or some third party site. So that's kind of like the general known situations. And then anonymous, without stating the obvious, is where it's anonymous in the agreement in that the names typically are not shared. There might be initials, but generally speaking, an anonymous agreement does not provide the names of the parties. The names are not disclosed to one another. So the attorneys should have the names of all the parties. The clinic has the names of all the parties. If there's an agency, they have the names, but the parents don't know the donor and the donor doesn't know the parents. So whether you're talking about a known or anonymous agreement, you have to get into within the agreement of what kind of future contact do the parties want as they proceed within their life. So taking a tiny step back, the donor, as long as everything's done in accordance with the state law, with the good contract, the donor is a non-parent. So they don't have parental rights or visitation or anything that they could actually legally enforce. However, these donation agreements set out kind of like the intentions of the parties as to what they want their future contact to be. So kind of the most strict, kind of anonymous language that I see is that the parties will just use their best faith efforts to provide any relevant medical updates to the clinic or the agency, which would allow that medical information that's relevant to the genetic material to be shared with the other party. So that's kind of like a baseline, and then it kind of builds from there. So then, the parties could agree to register with something like the donor sibling registry if they don't want to just communicate through an agency or the clinic. And typically with the donor sibling registry, or otherwise referred to as the DSR, generally the parents will pay for not only their own membership, but a lifetime membership for the donor to register. And that provides an intermediary way for the parties to contact one another, not just for medical information, but possibly to kind of be in touch and in each other's lives in the future. So that's kind of like another tier up where the parties are all signing up for this kind of like process that would allow them to communicate in the future. Then we get it even more expanded where the parties really just agree that they can contact one another directly to, in whatever fashion they decide in the future, be in touch. Because again, there's always the thought process that, parents do this donation obviously before having a baby, and they don't know what the child will want or need in the future. So kind of leaving the door open as to future communication, because once the door is closed, it's a little bit harder to open. So if the parties contemplate just that possible future communication, that's another level where the parties can freely communicate unless otherwise, asked to stop between the parties. So, and then you always get into the communication as to the donor and the child. Generally speaking, the agreements provide that the donor is not to contact the child without the written permission of the parents, if at all. So, that's an important thing to address. And generally speaking, the agreements contemplate that, the child is not a party to this agreement. You can't enforce these rights against an unborn party who's not a party to the agreement. So I do sometimes see language that any action of the child, potentially if they were to ever reach out to the donor, can't be construed as like a breach of the agreement. So as I said before, there are 1,000,001 ways to set up future communication, and I think a great way to best analyze future communication in donation agreements is to address it in your mental health counseling session. They are the best equipped party in this third-party reproductive journey to help the parents and the donor kind of best understand, wrap their brain around what disclosure should have in the future, what that means for the child, what the best practices are, so that way you can come to your attorney with fully thought out kind of like plans on what you want your future contact to be. There's no right or wrong. It's kind of a personal preference based upon what the parties want. But there are, guidelines that parties may want to consider following. So that's kind of a common theme in most of my videos is communication is key. Speak to your mental health professional, communicate with the agency what you're looking for, and obviously speak to your attorneys. And it's best to have an attorney for the parents and a separate attorney for the donor so everybody is properly counseled. Thank you so much. If you have any questions, please let me know. I'm happy to assist. My name is Marla Neufeld, a Florida reproductive attorney.